Hello, thank you for joining us for California Lawyers for the Arts annual Music Business Seminar. My name is Ned Hearn. I am an attorney in private practice, former board president, and current board member of the California Lawyers for the Arts.
My name is Gloria Ruiz Oster. I'm the Deputy Director and Southern California Director for California Lawyers for the Arts.
And I'm Eric Chun. I'm a musician and a professor in the commercial music department at American River College in Sacramento, California. I'm also a board member of the California Lawyers for the Arts. My colleagues and I are happy to welcome you to the 2021 Music Business Seminar. This year, since we're not able to gather together in person, we've put together 4 weekly webinars that bring together music industry insiders, scholars, legal experts, and marketing professionals to offer all the latest in music business insights to help you navigate an artistic career in 2021.
As a bit of background, California Lawyers for the Arts is a statewide nonprofit organization with offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego. CLA has been providing legal and technical assistance to the creative community since 1974. One of our core services is our State Bar Certified Lawyer Referral Service, which provides referrals to highly qualified attorneys who can work with you to resolve your legal issues in a professional manner. Depending on a client's income, legal assistance may be available on a pro bono or on a reduced fee basis. We also offer a specialized program in conjunction with the U.S. Patent Office that assists entrepreneurs and inventors and small businesses with patent applications. We also have a range of alternative dispute resolution services available, from negotiations counseling to mediation and arbitration, all of which can help parties involved in a dispute to avoid the expense of going to court and instead to find workable solutions through a confidential process guided by trained third-party neutrals. Lastly, we offer a year-long schedule of educational programs that include workshops and conferences and seminars like this one on various legal and business topics. Many of our previous programs have been recorded and are posted on our YouTube channel. And we hope you'll use these tools to stay on top of the legal issues that can affect your creative careers. We hope you'll follow us on social media to stay in touch and to learn about upcoming events.
Thank you to our sponsors and to the generous support we receive from our funders, members, and all of you here tonight for making this seminar and so many of our public programs possible.
I'd like to introduce our panelists for tonight, who will lead our conversation on inequitable music industry contracts, perils, pitfalls, and a call for reform. I'd like to welcome Lisa A. Cervantes and Professor Kevin J. Greene. Lisa A. Cervantes is the founder and owner of IP Legal Studio, LLC, a private entertainment law practice in business for over 21 years. Throughout her career, Lisa has specialized in TV, film, and music, clearing and resolving various copyright and trademark disputes. She has negotiated thousands of licenses and entertainment-related agreements on behalf of artists, producers, and directors. Registered and certified in practice before the United States Patent and Trademark Office and WIPO, she works with entities of all sizes to protect, license, assert, and defend rights in intellectual property, including trademarks, copyrights, and trade secrets. Lisa regularly lectures on copyright, trademark, and entertainment law at Thomas Jefferson School of Law and has presented at Southwestern School of Law, University of San Diego, National University in Los Angeles, and University of Turin in Italy. Next, I'd like to introduce Kevin J. Greene, who has recently joined the faculty at Southwestern Law School in Los Angeles as the John J. Shoemaker Professor of Law. Professor Greene's scholarship in the areas of copyright, trademark, and publicity rights has garnered national and international recognition in intellectual property arena, particularly his pioneering work on African American music and copyright law. His scholarship has twice been selected as among the best IP law review articles. In 2008, for a Right of Publicity article, and in 2015 for an article on idea misappropriation in Hollywood. Before becoming a law professor, he practiced law in New York at the premier firm of Kravitz, Swaine, and Moore, where he represented high-profile companies such as Time Warner and HBO. He also worked at New York's top entertainment law boutique firm, where he represented clients including film production companies and record labels, including director Spike Lee, Def Jam Records, and iconic music artists such as Harry Connick Jr., Bobby Brown, and the seminal rap group Public Enemy. Now, without further ado, I will welcome Kevin and Lisa. On behalf of California Lawyers for the Arts, it's really our honor to have you here with us tonight. We're very excited for the conversation that you will lead. And with that, I turn the floor over to you all.
All right, so I'm more going to talk about Perils and Pitfalls, while Professor Greene will handle a lot more of the reform section, just so everyone knows. And so by way of a slight review of earlier seminars, I'm just going to go down right now the list of ways an artist can make money in the entertainment business, and mostly this pertains to music. And so when I say artist, what I mean is generally it's a catch-all for all these different people. It could be a solo performer, a songwriter, a singer-songwriter, a band, a producer, a DJ, another musician, guitarist, drummer, saxophonist, record company, even distributor, manager, videographer, director, promoter, engineer. So you'll find that a lot of what I'm talking about pertains mostly to either indie artists or smaller businesses. I don't typically work for big studios. I have done a few things here and there that touch upon that, but I'm dealing with more small entities in my solo practitioner business. So that's where I'm coming from. Okay, so we'll start just briefly, as I mentioned, by discussing channels by which the artist's content may be exploited, which may or may not appear as contract terms in various agreements. So the first thing is quite obvious: digital sales. There's digital distribution and distributors, which may then or need to refer to the website for the artist, or the band, or the record company, or the producer, or the DJ, etc., etc. We've got, of course, sales outlets like DistroKid, iTunes, Amazon, Bandcamp, CD Baby. These are revenue sharing type outlets with their own percentages predefined. These types of digital sales may be advertised and promoted through audio and or video via social media like Instagram, Facebook, TikTok, Twitter, or by, of course, the traditional modes: television, print ads, social media, posters, concerts, events, you name it. Okay, then moving on, we've got digital streaming. This would include like Spotify, Pandora, Sirius, YouTube, Vivo. These are all excellent sources of revenue if you're dialed into that and want to self-promote. Note also, like with services like Vivo and YouTube, if videos are running ads, then advertising money goes to the rights holders of the songs. So you want to be sure you're signing up correctly and maximizing that potential income. And there's, of course, live shows, and this can vary depending on the act, but it's still a great source of income. For example, even DJs can make boatloads and boatloads of money for themselves and gain followings. Some examples are DJ Z-Trip, DJ Cassidy, who's become real popular while we've all been in lockdown. DJ Fingas, he's a client of mine. He travels the world normally playing shows. By this method, income can be increased. Of course, then there's tickets and physical sales of merchandise and anything that becomes popular. There's all kinds of different goods that artists can offer, of course, at merch tables or at fairs or festivals. Then, of course, we have all important that was discussed in earlier seminars, licensing. We've got both the composition and the sound recording. So if you're a writer, you definitely should be learning about licensing your comp, and or both, if you're both a performer and or you're a singer-songwriter and performer, and you own your own sound recording, then you can really capitalize on this particular method of income. So in licensing, your fees are determined by the copyright listings. So please be sure you've registered your work and listed it in all the appropriate areas. For example, ASCAP, BMI, Harry Fox, the MLC. I'm pleased to say I've had some wonderful conversations with the MLC already. I just learned about it a couple weeks ago from the Brayback brothers, and it's been phenomenal so far. So for all you MLC people out there, yay, job well done, helping us get our artist listings correct. So for licensing, what we're thinking about is marrying the song with the audio visual in a TV, a movie, or a commercial. Trailers for movies are quite a lucrative area, by the way, but even television commercials for, you name it, Target or Kmart, whatever, maybe not Kmart anymore. Anyway, then there's sampling. Well, all the areas that are licensable include sampling, replays, lyrics, sheet music. All these things are licensable. Okay, directly tied to that, of course, are publishing royalties. So revenue sources from the music composition is what we're referring to when we talk about publishing royalties. If you're a singer-songwriter, you'll want to guard these royalties very carefully. Master royalties, that's an item that will inevitably end up in a contract concerning your works. So we have to ask ourselves, who owns the sound recordings? Is it you, the artist, or is it a larger entity, a record company you've signed with? Even a distributor can own a portion of sound recordings or have a right to collect royalties based on the sound recording. So here we're concerned with mechanical royalties, and this is where the MLC.com comes into play, or Sound Exchange, or both in conjunction. If you write, arrange, pay for, or self-produce, you'll want to own your own masters and the royalties that flow therefrom. So next, we're thinking about live performance royalties. When an artist or a cover artist performs a live composition, there's payment through ASCAP, BMI, CSAC. There's a fourth one, it's not coming to mind. These are the performing rights societies. My personal rule of thumb to my artists, never ever share these if you have a choice, and you always have a choice. Everything is negotiable. Sales of physical music is our next area of exploitation opportunity. Indie artists, of course, would need a source for reproduction and distribution if they're doing physical sales. Just a little rule of thumb, self-creation might be easy, but reproduction and distribution can be overwhelming. So you may need to search for a distributor for this. Again, physical merchandise. If you register your name, your logo, and branding as trademarks, logos can also be copyright protected, just like album covers, etc. Touring can help sell t-shirts and other souvenirs and become lucrative. Okay, then we've got, of course, digital merchandise, which is all important in this time frame. We've got music, PDFs, videos, images, lyric books, live concerts, electronics, light show. For example, if you are an innovative type artist, you might create something special like a light show or a playlist that goes with your particular performance, but you may also find a way to sell that. I have a client that does that and has made a lucrative business providing items for artists to tour with. Last but not least, we've got sponsorships and endorsements. An artist can be the face of a music brand, and a brand can popularize the artist. The artist can endorse products like energy drinks, clothing line, music gear, etc. The brand can sponsor the artist's efforts, for example, concerts, tours, appearances, and performances. So this list, of course, is not completely and totally comprehensive, but it covers the main areas where an artist can make money, revenue streams, and that's a good thing. Okay, next I'm going to shift into what an artist or entity, again, Going back to my definition of artist, is sort of all inclusive, small companies. If you are searching for an attorney or some legal help, what should you be looking for when you're seeking legal help? So this list is based upon somewhat feedback from my clients, just representing clients for many years, and of course, negotiating contracts and seeing lots and lots and lots of bad and unfair contracts. So I've sort of just brainstormed on what, if I were standing in the artist's shoes or the startup company's shoes, what would I be looking for in a lawyer? So the question is, what attorney roles or skill sets should be considered when seeking legal help? Well, I firmly believe the legal team should be totally up to date on their artists' projects, talents, capabilities, and revenue streams. Now, you may find it as a lawyer, if there are lawyers out there listening, there may be some. It's impossible, of course, to watch every movie or every show or read every script or listen to every song that your artist is producing. So at least, though, take the time to do snippets or watch parts or just catch up or get a synopsis so that you have, a general idea. I say this because, for example, a client of mine wrote a long book, and it was a fascinating book, but I didn't have time to read it all. So I read, half of it so I could get the idea. And now the documentary is forming around that book. And thank goodness I know what we're talking about when it comes to the contract and the different interviewees that will be in the documentary. And then next, an attorney should want to preserve artist percentages in artist works. So you need to be aware of conflicts. Sometimes an attorney will try to represent both a record company and a manager. And while that's not illegal if they have a waiver in place, it still can signal a conflict of interest. So you need to ask yourself a question about that particular thing. It's just sort of the same as checking to see whether an entity that you are contracting with is in fact a registered corporation or is not, a suspended LLC or something like that. You want to be sure that everything's on the up and up. Okay, copyright and trademark registrations. I think that in this business, your lawyer should be recommending and assisting you with the protection of your IP, period. That's sort of like a baseline requirement. Attorney also should be able to competently draft, review, negotiate, and finalize your contracts. Always be sure to give your attorney the fully signed agreement. This can be crucial for issues arising like termination or enforcement. The attorney should also be able to explain to you in very clear terms what language in the agreement means or why it should be eliminated or added. That then can assist you in explaining it to the party on the other side of the deal, or at least get settled in your own brain of whether you can live with that term or not. An attorney should be able to review the content and protect you against infringement from third parties. These things should be paramount in the attorney's mind on your behalf. And this includes just asking you, the artist, is this originally created by you? Or did you borrow a sample from so-and-so? If you suspect that, as the lawyer, speaking from the lawyer's point of view, ask the client. As the client and the artist, please be honest with your attorney. It doesn't benefit anyone if you aren't. If there's something that needs to be cleared, for example, we can do that for you and keep you in the studio creating. Okay, publicity and privacy rights. Your lawyer should be mindful of these rights in any and all of your agreements. For example, they're going to appear in management, appearance agreements, recording agreements, marketing agreements. Obviously, a publicist's agreement would have a huge blurb on publicity and privacy rights. Those things, people, especially in a recording agreement, they want to get a hold of owning your publicity rights. And we would like to see you preserve those as much as possible. Just give away what you need to make the contract function. Connections. Sometimes you need an attorney who's got a specific connection to executives where you'd like to be. For example, if your content is perfect for Disney, you may require and desire a firm that regularly interacts at Disney. So ask yourself when you're searching whether that kind of thing is important to you. Shopping. I get asked all the time, can you shop this? Can you shop that? Can you shop my music to obtain a recording contract? Can you shop for me to be able to perform a concert with so-and-so? Can you shop for a distribution deal for me? Can you get me an appearance on such and such a TV show? Can you shop this project for acceptance at Netflix, etc.? I personally don't like shopping, and I will only do it under certain circumstances. And that is usually if an artist has a list of people that they have in mind for me to shop to, then I will go ahead and put requests on my letterhead or send them out through email. And this method for me works very effectively because I don't have to start from scratch and I don't have to consult my book of contacts and make the matchup between their project and the person. And while I had been very, very, very social in the first 10 years of my practice, I'm less social now. So I don't love running out to parties and making contacts so that I can share them with my clients. But there are many, many, many attorneys that love doing that and are fabulous at it. So as an artist or entity that needs this, please ask, because, there's enough of us to go around and serve all your needs, basically. Okay, tied into this a little bit is an attorney. You need to kind of flesh out what type of an authority or a name or a tone you need your attorney to keep for you. So this is a little bit tricky, but the attorney should have the ability to morph in various situations. In one case, you may need to be assertive. Another case, you may need to be mellow and be a sweet talker. It just depends on who you're dealing with. So you need a lawyer that is pretty flexible, because creative people are creative and they're tender and they're sweet and they're soft, and they're usually contracting with someone who's at least a little bit like that. And so sometimes the aggressive approach is not always the best. On the other hand, there's some tough cookies in the business, and sometimes you need to be a little bit assertive or aggressive. So the artist also may need an attorney who has a name in the business as being strong against certain entities like publishers or habitual infringers. There are people that, sue the guilds, or they have a reputation in the business of getting results on a copyright infringement suit, let's say. So you may be looking for that, and you want to search for, a named attorney for a certain purpose, perhaps, or you just feel like you want to have the best for yourself, and that's great, but please do have this in mind when you're looking for an attorney to represent you. Again, you might need an attorney who's always aggressive or the best at appearing in the media or on the news, or you might just need a soft-spoken attorney to make inquiries. We're usually not just one way. We can, as I said before, morph, but you need to kind of, understand if it's a fit for you. You also need to ask, is your attorney an IP protection specialist? Can they effectively combat infringement as to your work? Are we capable of sending a cease and desist letter to someone you have infringing? These days, you sometimes have to track people down via Facebook or IG, it's crazy. You may not easily find an address of an infringer, someone who's putting up infringing material, either songs or this happens a lot in Trademark as well. So you need to be able to have the flexibility to send your cease and desist letter right through the messenger if needed. I've had to do this like 4 times in the last year, and it's worked every time to shut the other guy down, knock on wood. So that's been lucky, but just little notes. Do you need a litigator? One who can file lawsuits, both prosecution and defense, at, say, the Trial Trademark Appeals Board or the U.S. District Court or in state court. So if you need litigation, you need to be searching for someone who is willing to litigate. not a transactional entertainment attorney. Okay, so I personally want an attorney who's always learning, who's up to date with awards and, the Grammys and the Golden Globes and new artists, new cases, someone who's attending and presenting at continuing education, teaching, earning another specialty degree, or publishing. These types of people are much more likely to be dialed into your unique situation and give broader opinions. Also, you need to be positive sure your attorney is able to go to mediation or arbitration for you. They need some minimal experience in the alternative dispute resolution arena. And of course, please do as I do and name California Lawyers for the Arts as your first stop for mediation of disputes in every agreement. I religiously do this, unless somebody's arguing the venue should be New York or something, and then I sometimes don't have a choice. But okay, these are just a few examples of common terms for negotiation that may be unfair, they may be inequitable, and they may tie up the artist. I'm going to start with a couple of sneaky negotiation tactics. And some of these are actually like before you've seen the contract. You're going to read the preamble email. I mean, I've seen this so many times, particularly with reality shows or bigger producers where the producer's well known and the artist is just lucky to be chosen to be in that production. So the first one is, this agreement must be signed within 24 or 48 or 72 hours, or it's withdrawn. So often the artist is coming to the attorney saying, you have 2 days to whip this out. And so you may think that it's a lack of funds, but this is the number one reason artists don't get attorney review and enter into terrible agreements, because they're scared. They're like, oh no, the offer's going to be withdrawn. I'm going to lose out on this opportunity. I don't have time to go in and pay a lawyer or find a lawyer or wait for the lawyer. So they just go ahead with it. And then a million times a million in my life come back to me, I already signed this. Is there anything else I can get out of this? And just know this, it's much more of an uphill battle at that point for us. So don't be scared. Don't worry if it says you have 1 hour to sign it. Go get help. Please, I beg you. Okay. Anyway, please be well advised that it's almost never necessary to sign it that fast. If an entity has sent you a proposed agreement, it's because they recognize your talent and want to capitalize on it. Thus, they will wait for your thorough review and negotiation. And that's almost always the case when you come back to them and say, hi, I've got a lawyer. They'll be with you in a week or so, or something like this. Or the lawyer can write for you and say, listen, we're reviewing this and we'll send you our markup, soon enough. Okay, so the second sneaky tactic, these terms are not negotiable. I'll repeat it again and again. Everything is negotiable. Everything, literally, okay? Just please know. A list of everything you, the artist, would want and more should be made even before contacting your attorney. If one term can't be altered, maybe another one can. So there's give and take there. Never be apologetic for reviewing, understanding, and negotiating your own terms, governing the rights in your own creations. You don't need an attorney to review this. That's the third sneaky tactic. I, or the company, will explain anything you don't understand. Or worse, I'll tell you what attorney is acceptable for reviewing of your agreement. False. Absolutely false. That's self-serving and signals a ripoff about to happen. Borrow or request payments if you have to get an attorney review. And I will add a little comment in too about making a list. You make your list and, don't be surprised if your attorney sees 10 more things that should and can be negotiated on your agreement. Don't be, make your list, but don't be stuck on your list, because there are many things we know that you don't know that are good for you. And we're going to help you make sure you get the best. Okay. The fourth sneaky tactic, games regarding who will present the first draft of the agreement. Sometimes entities will say, we'll do it. And then, no, I changed my mind, have your attorney do it. This gets really expensive. So if you're the starving artist trying to make it, you're going to want to ask somebody to present you with an agreement. Then you're going to want to take that agreement to the lawyer to have them review it, because it's easier for us to do a markup than to draft something from scratch. But it's not always possible. Sometimes I see agreements that are so horrible, I literally just copy some of the terms I like and throw theirs in the trash and draft my own on behalf of the artist. So that happens too. But in general, if someone gives you some paper to document the deal you're making, that's a good sign, and we can usually, start negotiating from there. If a record label is signing you, you'll want them to present an agreement, kind of rule of thumb. If, on the other hand, you're seeking a manager, it might be wiser for you to have your attorney draw the agreement. So you can ask your attorney for the best advice on this particular tactic. Again, those tactics, quote, are not the whole list of crazy stuff that can come from outside people or people you're contracting with, but they're the main ones I could think of that really bother me from time to time. Okay, jumping into some typical terms in contracts. First one, of course, is going to be the price, and this can refer to advances, to royalties, to per episode fees, to profit participation, back-end profit participation. Then there's the question of gross or net. An artist will always want to fight for gross, and the company will argue net on profits. What does that mean? It means that after the company pays all the costs of its production, whatever net profits it's got left, that's what it wants to share with the artist on a profit participation deal. The artist will say, well, no, I'm a top artist and I want to get gross profits off the top. I want 50% of whatever this thing makes, and you guys can take the rest, the other 50%, and do what you have to do. Now that works pretty well for like a distribution agreement, but if we're talking about a recording contract or something else, there's going to be some push and pull there. Okay, when you're talking about price terms, you want to note whether it's an advance for production of an EP or an album. Is there a marketing and advertising advance? Is there tour support money provided? The more 360 the deal, the more price terms I will want to see for the artist. If there's no price provided, then there better be some other huge benefits like credit or working with a top-notch artist, or future, we're going to use your music in future productions and then we'll pay you kind of thing. So there's like all kinds of different sliding scales. We can go back and forth here, but please look for money in your contracts. Know that somebody really, really wants to do something for you by giving you something for your time and for your talent and for your creations. Okay. Term, this refers to time. So the term is the time that the artist will be held in contract with the company, or the time frames within which the artist and the company have to perform certain duties. So ask yourself, is this an option with a set expiration period? Are there excesses or endless extensions for this or that? Is it contingent or dependent on other occurrences? Is it a recording contract? Is it a production deal? Certain types of agreements have certain standard times for each, ranging very generally from 6 months to 18 months and beyond. And then, unconscionable terms are oftentimes proposed in the term section. Sometimes contracts, for example, a management contract, they'll say, we want you to be in the, we want to manage you, artist, for 3 years. That's really long for a management contract. Now, if it's like, a super famous manager, maybe you're so delighted to ever be considered but being managed by them, okay, it might be worth it. But if it's just someone starting out, you want to have maybe a year, maybe 2 years max with renewable terms. You want to be renewable. If things are working out great, everything's moving along swimmingly, fine, you're going to renew that instead of be locked into such a long time right up front. Okay, next up is exclusivity. Unless the artist is being paid or having a huge benefit conferred, like I just talked about, like exposure from a reality program like Idol or The Voice, these terms should be as limited as possible or be changed to non-exclusive. An artist needs to preserve his or her freedom to earn a living doing art. Singer-songwriters should avoid exclusive agreements whenever possible so they can maximize all those revenue streams I talked about at the beginning. Okay, next we're going to talk about pre-agreements for non-objective representation. If you see these kinds of things, please be alerted. This is a red alert. They go something like this. We, the producers or the label, decide who your current or future label management, recording producer, engineer, mixer, videographer, stylist, and even attorney is going to be. No, no, no. You want to be able to decide that for yourself. It's your life, your career, your choice. Don't give that up unless you absolutely have no other option. Okay, next, exclusions. Producer label may have language that limits the artist's ability to write artist's own book, keep rights in own life story, perform live at your own show, enjoy your own publishing and master ownership, have a say over how many days here you work, understand what control should be given to third parties. For example, managers, booking agents, music directors, and what should be reserved to artists. Our job as lawyers is to create the carve-outs so the artist can continue doing ongoing projects, other lucrative income streams, and charity work, or whatever's on their list. You want to be sure also to exclude regular work just to pay the rent. So if you're working part-time as a waitress or a driver or whatever, you need to be able to make sure you can do that job. So you don't want blanket statements like, all of the work of the artist belongs to the record company. No. Okay, extensions and holdovers. Artists, please beware here. Publishing admin agreements frequently have these provisions because of all the registrations a publisher has to make. It's a big job to be a publisher. I don't take away anything from my publisher people. They're awesome. But at the same time, these long provisions can be really mind-numbingly horrible. Like an artist must give precisely 1 year notice to terminate, and after termination, then the publisher has an additional year to collect, and then additional time to remove listings and transition the artist back to self-publishing or to another publisher. So it can be really nightmarish. Some of these publishing agreements are written extremely archaically, and they started from the beginning of the very tight ship of the music business, which Professor Greene's going to discuss after I'm done here with you more. So some of the language that comes in these agreements is just very old-fashioned and really needs to be reformed. So it's up to you to see it and raise your hand up and say, attorney, handle this for me because it's looking terrible. Okay, audit rights. Be sure that those provisions are included to govern any ongoing royalty or profit shares. I can't tell you how many times that's missing from agreements, and I just have my standard clauses or clauses that I tailor and get right in there. Reversion rights, again, ultra important. Be sure that if the promising party you're contracting with isn't performing or another contingency isn't met, that the artist rights granted in such an agreement revert to the artist. You want to really be sure you're getting something back if something doesn't happen that you've counted on happening. Okay, termination. Be sure to preserve rights to get out of any agreement for regular reasons, like a pandemic started and concerts were canceled, storms, illnesses, unconscionability. I was unaware or the agreement is so restrictive and unfair that it should be canceled. Time is tied back to the term above. Negotiate the shortest possible route to realize success for all parties. So be sure you preserve your right to terminate if, the album wasn't assigned to a distributor in a certain amount of time, for example. Okay, so present day problems I see frequently this ownership of rights and percentages are really perilous. So here's the first example of probably one of the worst things I've ever seen, just because of the words that were exchanged and the threats and this and that. So basically, there's this widespread use of internet contracts by non-lawyers with provisions gutted or changed or otherwise rendered insensible, and then signed without the presence of lawyers or advice given on either side. So a young client came to me, a young woman named CR, and she signed with this young hustler named HD, who invented a company name, then used this giant old-fashioned recording contract that part of which was, like I said, insensible. It was just, misspellings and sentences pasted together. But bottom line is she signs this without any lawyer looking at it, then faces the threats from HD that she can do nothing to change the provisions that she signed, while he sits back and collects like he did with XY artist prior in his little hustling career. Basically, he's done this to someone else. He's figured out how to get them to sign an old-fashioned recording contract, just being a fast talker at the table. And then when they tried to wiggle out of it, he said, no, I'm going to just sit back and collect any and all things you do. So my client, CR, literally believed she was signing a management agreement. But lo and behold, I get the contract finally. It's a recording commitment for 5 terms of 24 months, literally 5 albums in 10 years' time. So amongst other horrifying terms, it binds the artist's young soul as follows. Says the company shall be the sole exclusive perpetual owner of all the results and proceeds of all masters and records recording during the term, embodying artists' recorded performances as works made for hire under all applicable copyright laws, excluding the copyright in the underlying compositions. But then later they captured the compositions in later clauses, including masters, demos, which ownership entitles company to the exclusive perpetual rights. That means just us, forever and ever, in reproduction, distribution, public performance, synchronization, sale, advertising, marketing of the masters or any remixes thereof, and to permit others to do the same in any format, any and all markets, and rights to name, trademark, logo, likeness of artists. Plus, they captured ancillary rights, film, TV, endorsements, sponsorships, books, magazines, websites, games, concerts, other entertainment services of artists. Plus, that's not all, 50% of her publishing. And company is exclusive publishing administrator. Now, I need to add that she's a singer-songwriter, so that's big. Just taking 50% of her publishing and all the rights in her masters. So without further ado, I will jump into how can an artist fight or oppose these things. This is already done now, right? It's inked. She signed it. He signed it. I've got the contract in my hand going, oh no, what in the world can we do with this? So this is where we have to be good dismantlers, right? And look for ways and things the contract says that are able to be picked apart. So first thing I did in this instance were to look for term time clauses that are confusing or not solid, or rights that attach contingent to certain events occurring, like the delivery of the masters triggers an option period ending a duty on company to enter a distribution deal. So in other words, if the company hasn't entered that distribution deal upon the delivery of the masters within 6 months, that voids at least that part of the agreement. If the option period ends, can artist escape? I say yes. Breach or non-performance of duties promised by company can suffice for good arguments that artist isn't bound by the contract. Note I said arguments. We don't know whether a court would uphold it or not if it got to that point. But you need to be honest in acknowledging what was done by all parties, then cite what wasn't done. For example, the young hustler paid for some photography for artists. He did pay a little bit, according to what he had promised to do, to help her get the look to go with her records. Be thorough in citing all circumstances surrounding signing the contract. That when signing artist was young, naive, from another country, didn't understand English or the legal terminology, didn't have an opportunity for attorney review, and that ultimately this person posing as a legitimate company obtained her signature under unconscionable circumstances. Document all of the above with a formal termination agreement sent to every found address via certified mail. And this is where, you need to be thorough and scary, because you want to let this person know, look, we are totally going to sue you for this if you don't let her out. So this sends the message that you are serious about protecting the artist's rights and will fight with legal counsel. It also serves to create a solid timeline in reclaiming artists' rights should there be ensuing litigation. So even if the company doesn't sign it, and in 80% of the terminations I've ever sent, they refuse to sign. And that's fine. As long as my client is signing and they're not popping back up, at least then we can show, look, we really, really tried to solve this issue. Also, require evidence from the other party. If they haven't performed, they likely can't produce such evidence, and their arguments without valid evidence will fall. Understand the difference between irrelevant and unsubstantial ramblings and true factual evidence, like real damages suffered, etc. Okay, second example, I'm going to breeze through this and then wrap it up. This is an instance where the client didn't quite know what all might be good for him, so I had a bit of an uphill battle in just convincing him that the things I was asking for in the markup are things he should want for himself as an artist. And eventually we worked it all out real lovely, and the project went on to see smashing success. So I'm real proud of this, that we did everything exactly correct, in this. So this was a recording and a music composition license agreement, and some of the terms that we negotiated. So this agreement concerned a 50-50 agreement for a set of compositions between my client, who was the person creating the melody and the track for the song, and the performing artist, who writes his own lyrics and then performs the song. And he's a singer. So my client and the performer had a prior history of writing together and enjoyed a good creative relationship. So when my client came to me, he was quite nervous that I would interfere with that. And I said, no, don't worry. I want to see you work together well, but also get paid for your efforts and get what's right and fair. So the attorney for the performer was in New York, and not surprisingly, he was running a music label and proposed the contract, which included specific provisions to have my client assign a percentage of my client's publishing rights. And we said, absolutely no way, Jose. No, we're not doing that. So some of the terms were: the territory was the world, fine. Compositions here, be sure to include, this is what I usually do in a license agreement: name of track, the timing of track, the composers and percentages owned by each composer. They can be attached as a schedule or a chart. I'm real fond of schedules or charts. They're just easy to fill in and not miss anything, like the timing of the song, etc. You want to be very sure you know exactly what song you're talking about, or songs, set of. This was an EP, so it's 4 songs. You want to put in that the royalty, the net profit split. So in the mechanicals, we agreed to split 75% of the master's mechanicals and letting the performing artist own those masters in order to compensate the music label performing artists for their work in providing the song video to the world. And this was done like on a balancing act with this publishing thing. We argued about that. Okay, we'll go ahead and do that 75. That's sort of a typical thing with big record companies, but you're not going to even take even 1% of publishing, because you attorney for the performer are not the publishing administrator of my client's publishing rights. So he was a younger attorney and I had to school him a little bit, or at least as to this one, I said, you shouldn't be trying this. It's not really good. Anyway, co-composer and master owners will pay to you 100% of the licensor's respective share of all income derived solely from the compositions. The proposal was 75%, and we said, no, we're taking 100. So then in letters of direction, there were letters of direction attached to this letter style contract. And I can't emphasize enough to artists that they should really be attentive to who you're agreeing to designate to do what. Attorney who has a record company is trying to become the publishing administrator in These Songs Forever and may have my artists assign rights to him. I see it as a conflict of interest. And if he's licensing on behalf of his client, all he need do is contact the artist and ask him to sign off on any licenses and pay artist his proper percentage share. Okay, so what was preserved here are my client's rights as a composer to provide underlying music to another artist for new lyrics, create his own lyrics for re-recording, or publish the music on his own to his own audience, even if instrumentally. So it's big. Next, with no further ado, thank you for your attention. I'm going to hand it right over to Professor KJ Greene, lawyer extraordinaire, and my personal friend and mentor.
So first of all, I want to say thanks to CLA, which is doing great work and really helping people. And CLA really gets it that, copyright and IP and all this other stuff, it's about people. And so many times, when I'm dealing with people in the academy, they don't get that it's not just some theoretical stuff or some doctrinal, mishmash. This is ultimately about people. And I love the CLA is really down with the people. I also want to thank Diana, who has been fabulous in putting these events together and works very closely with us. She worked very closely with myself and Lisa. Diana, thanks so much. And of course, Alma, who is kind of masterminding this whole thing. So I just want to say many thanks. I also want to acknowledge my good friend and colleague, Lisa Cervantes, who, as you saw, is an absolutely terrific attorney. When I have things to refer, as she knows, I refer a lot of things to her. Everybody is really, really just astounded by the things that you think of and your creativity as a lawyer. So I'm very proud to share this stage with you, Lisa Cervantes, and thank you for that tremendous presentation, which was chock full of information. I think that was useful to pretty much anybody. So CLA has also been a space for me for innovation, because when I was here last time, I basically, instead of doing a traditional presentation, I ran my presentation through the paradigm of my book. It's not forthcoming because I don't have a publisher yet, but I hope I get a publisher. And my book is called The Copyright House of Horus. And it explains the horrible ways that copyright law specifically has treated African-American artists through the lens of a biracial kid who's based loosely on my son, who's now 21, but he was 18 or whatever when I started this, who's struggling with these issues of racial identity and trying to learn more about his history and his culture. And so the book is a vehicle to kind of tell his story. And it's a crazy book. It's part fiction, part truth. I don't know what a publisher is going to make of this, but I'm certainly excited about it. And I might do a little bit of that today. But you've also helped me try out new things. So thank you, CLA. Today, I'm trying out something new again. This is the title of this article when it gets published is It's Yesterday Once More, Inequitable Music Industry Contracts from Jelly Roll Morton to Cardi B. And of course, I talk about in the piece how law school, and I teach contracts, by the way, in a law school, contracts is celebrated as this engine of, capitalism and the economy and wealth creation and the rallying cry of contract doctrine and theory is freedom of contract. You are free to contract. That means you're also free not to enter a contract. It's two things: free to enter, free to get out. Lisa talked a little bit about that, right, in her presentation. And of course, it was created by these old white judges in jolly old England, starting back in the 1500s. And by the way, that is still the law that's applicable today in California and all across the United States, right? It's not something on some history book that you blow the dust off of. Of course, I talk about how this was created by the British aristocracy. By this, I mean contract law. It was created by them, and you know who it was created for? It was created for the British aristocracy. So right from the outset, we're going to have problems if we're trying to look at contract through the lens of equality, because that's not what it was designed to do. It was designed to protect the property, particularly of the British aristocracy. And it still is today, by the way, in Britain and the United States. And so my story is a little bit different story. Public Enemy in Fight the Power said, most of my heroes don't appear in those stamps, right? In Fight the Power, one of the great songs of the 1980s. Well, my old client, Public Enemy. Well, most of these stories these contract stories don't talk about the African-American experience. And so before I get started on this, I just want to say one thing, because I want you to know that this isn't about Black people. It is about Black people, but it isn't. Because when we fight for equality, whether for Black people or trans people or women, everybody wins, right? That's the point here. And because African Americans have been at the bottom of the totem pole and still are in American society, I've always said that we should create legal systems, whether copyright, IP, contracts, that are consistent with that. And in fact, that's very consistent with everybody who writes about the rule of law and John Rawls and other people, distributive justice. We measure a legal system, not how it treats the rich Wall Street guy, but how it treats the person at the bottom. And that's how we ought to measure an IP system, a copyright system, and a contract system. And so deal with me here a little bit in this presentation. Okay, so common law contracts. Common law contracts, it means the law that was created by judges in England and now in the United States. And it's still the law that's with us. Everything that Lisa was talking about is common law, pretty much. I don't think you talked about any statutes, right, Lisa, in your presentation. So, and there are statutes that are applicable, but we didn't talk about those. And of course, my thesis is that common law contracts particularly is hostile to the interest and the position of African Americans and anybody who's at the bottom, actually. So we have things like in the doctrine, and we still teach this, and it's still the law. This is not 1500, it's 2021. Adequacy of consideration is not a defense to getting out of a contract. Courts will generally not examine whether you made a good deal or a bad deal. And common law courts particularly were brutal about this. And they wouldn't let you off the hook. They said, well, that's too bad. You should have made a better deal. Well, unfortunately, we're not all equal in society. We don't have equal education. We don't have equal resources. And by the way, in American society, it was deliberately set up. It's not an accident that African Americans don't have the same educational attainments and don't have the same economic wealth, home ownership. Those are all baked into the cake. It was called Jim Crow. It was called discrimination. Well, guess what? Contract law doesn't recognize that. Earlier today, Lisa and I were talking. As always, I always learn something when I talk with Lisa. And she was telling me about this guy who I didn't even know about. His name was Charles Stepney. And I read up on him, and he was the kind of the muse behind Earth, Wind, and Fire. And of course, we all know Earth, Wind, and Fire. They did great songs like this. That is Shining Star by Earth, Wind, and Fire. Earth, Wind, and Fire, man, I grew up with them. I loved them. They were tremendous. Still are tremendous. And of course, the thing was that he was entering into contracts with other members of Earth, Wind, and Fire, particularly Mr. Maurice White, who seemed to be the mastermind of the group. But they were oral contracts. They were oral contracts. And one of them was 2 years. Well, all my law schools know from law school, that's a big problem. Contracts that cannot be performed within 1 year of the making thereof must be evidenced by some writing that's signed by the party against whom enforcement is sought. That is old school contract law. That's new school contract law. So those oral contracts that you entered into might be completely invalid. Of course, this is a problem because many times, who knows that rule, right? That these certain contracts have to be evidenced by a writing. So people at the bottom of society are right from the taking. Based, if you know the rule, you can say, okay, great, I'll agree to this. Oh, great, I actually didn't agree to anything. That contract's unenforceable because of the statute of frauds. The parole evidence rule, the rule that says that whenever there's an oral agreement that happens first and then later on there's a writing, guess what? The oral agreement disappears. It's not counted. You can't use that. So things that you say in the bathroom before you sign the deal aren't part of the deal. But how many artists are in the bathroom? Because a lot of times that's where the things go down. And, the record producer is telling them, oh, yeah, don't worry about that 5% royalty rate. We'll boost it up in 2 years to blah, blah, blah. None of that's part of the contract, right? So all of these things are going to hurt people who are typically at the bottom of society. And most of the time that happens to be Black people. Of course, historically, we had African-American artists through the race record era, which lasted up to the early 1960s, that had discriminatory contracts. Now, a great example I always use, of course, is Bessie Smith, the great Bessie Smith, the Empress of the Blues. And Bessie Smith signed flat fee deals. She was the greatest artist of her time, certainly African-American artist. And she made a significant amount of money with the company, which today we would call Sony, right? It was the one who owned it. Columbia Records, now Sony, part of Sony. However, she was horribly taken advantage of in those contracts. Commensurate with what she contributed, she basically floated Sony. The Sony we know today wouldn't be Sony without Bessie Smith. Go back and look at your history and you'll find that, right? I think about Jelly Roll Morton, who claims to have created jazz and has a pretty good argument that maybe he did create jazz. Jelly Roll Morton. He's certainly right up there with the founders of jazz. He spent the last years of his life walking the streets of LA completely destitute, and he died a broken and poor man. This consistently happens to our greatest African-American artists, right? time and time again. It's a pattern and a practice. It's not a one-off. So Lisa knows how music publishing works. If you wanted to buy the rights to Tutti Frutti, a song created in 53 or whatever year it was, you would need millions of dollars. Am I not right, Lisa? If you wanted to buy that song, you need in the millions of dollars to buy it. So understand, even though this music is old, it's still tremendously valuable. By the way, it's all still under copyright. Anything after 1926 is still under copyright. So even if this is an old problem, it doesn't matter because all that stuff is still out there. It still makes money. And Little Richard signed it away for $50. Later in his life, he was able to get some of that money back, right? He was able to shame the record labels to do it. This is a persistent practice pattern. And it's all based on contracts in the American music industry. So, of course, that's Jimi Hendrix, All Along the Watchtower, universally acclaimed as the greatest cover record ever, by the way. Dylan wrote that song, but Jimi Hendrix defines that song, right? All Along the Watchtower. So I've talked before about his infamous PPX contract in 1964 that he signed that said he would convey everything that he created from 64 to 69 for the princely sum of $1 and a 1% royalty rate, right? That must be probably the worth. If you wanted to acquire the Hendrix catalog today, you'd need probably close to $1 billion to do that. Just understand, if you understand how, now, fortunately, his family controls those rights. They finally were able to wrest those rights back. This is Music History 101. So we went through this long period where African-American artists were being treated differently in contracts than other artists. And by the way, I've been challenged on this for years, but no, that's not true. Hey, I addressed it in the book, right? In the Copyright House of Horrors. In this section, they're at the Contract Wax Museum and Hall of Shame. It's a contracts hall of shame about all these terrible contracts that artists entered into over the years. And the African-American youth is surprised because there's white artists there too in this Wax Museum and Hall of Shame of contracts. And he says, the guide who's guiding him through this says, look, it's not just about African-Americans. He talks about the Beatles. Their first record contract in the early 1960s was horribly inequitable. The Fab Five gave up 25% of their earnings to their manager, Brian Epstein, who was a terrible negotiator. Their first record deal netted them about 1% per record sold on a 7% royalty rate. And perhaps worst of all, their manager sold off 90% of their merchandising rights, leaving the Beatles with just a 10% stake in merchandising. And Lisa addressed some of those things. As you can see, that is horrible. And look, who else is in the Wax Museum? It's Elvis, who had a notoriously bad contract with his manager, Colonel Parker. Elvis gave up half his income from entertainment sources in his management contract. Still, Elvis, who made a career off of imitating African-American performers and fueled by African-American composers like Otis Blackwell and Big Mama Thornton, had record and publishing deals that would never have been offered to African-American artists in that era. Then we see there's going to be this trial. And what it is that it's a trial by what I call the pantheon of dead white judges, these common law judges, and these artists who've been taken advantage of by contract. And so they have this trial. And we note that the grand prosecutor comes in, who was an elderly but slim and incredibly fit woman. And she cried out, "Inmates, prepare to state your cases in the august and honorable court of the common law. This is the law that comes from the motherland, jolly old England itself. And it is unyielding and unforgiving, particularly as it relates to contracts. Today, you shall be appearing before the pantheon of dead white contracts founders who have shaped this law." She was surrounded by deputies who bowed with deep reverence at the mention of the founders. The grand prosecutor shouted, "Forget not that common law still governs contracts signed, whether 200 years ago or to this very day. We consider this law divine. It was created by and for the British aristocracy, but while aristocratic in origin, it is part of our American heritage. You must respect it." Drake looked around the courtroom, a stately edifice with soaring high ceilings and depictions of liberty and old dead white people's portraits, right? And then she goes through it. All these artists who come before the court, they all absolutely get slammed, right? There's Justice Blackstone is there, Justice Cardozo is there, all these great judges are there. And Howlin' Wolf comes before the court. They say, "State your name." A large, powerfully built black man stood and came before the court. "My name is Chester Arthur Burnett, better known as Howlin' Wolf, born in 1910 in the hill country of Mississippi. I was in the Army in the Great War, a real horse-riding buffalo soldier, just like that Bob Marley fellow sang. You might say I is the original voice of rock and roll. Why, that famous DJ, Wolfman Jack, he took my name and imitated my voice to make his career. I came up with Sun Records, the same label that broke Elvis. I was there, Muddy Waters was there. I was weaned by Charlie Patton and Robert Johnson. However, like many colored artists those days, I was paid flat fees by Chess Records, my label, and they played a lot of shenanigans with my royalty account, such that I always came out in the negative. I'm here demanding some justice. The grand prosecutor smirked. Howl away, but show some respect for this court. Demand indeed. Next applicant. So she dismisses Howlin' Wolf, and everybody who comes before the court gets dismissed. And by the way, don't think that that's just something that happened in 1940, 1950, 1930. That is happening today. That happened in 2014 when I went up to the Ninth Circuit with George Clinton. And, no mercy whatsoever. So we could go through that again and again. I just wanted to talk briefly because I want to leave time for questions. Conveyance and copyright transfers. Now, there's only one part of the entire Copyright Act that ever mentions that there could be inequality, believe it or not. It's in the current act of 17 USC 203. It's the copyright termination provision. And these are provisions that say that an artist who signs a bad deal can recapture those rights 35 to 40 years later, depending on whether it's published or unpublished. I'm not going to get into all the nitty gritty of that, right? And so Congress recognized that there's inequality in contracting. That's why they put that copyright termination provision in there. And it says that you cannot waive or give up your rights to recapture your work, notwithstanding any contract to the contrary. That's right there in the statute. So it doesn't matter if one of Lisa's clients today, and Lisa wouldn't allow this because Lisa wasn't around, she was in Hawaii or she was on vacation, and they said, great, I'm signing a record deal. And the record deal says, okay, great. As part of this record deal, you also agree to you can never terminate and recapture these rights. Well, that would be completely illegal. The copyright terminations don't present that. So that should have been a fix, but it's not. My article is forthcoming in the Journal of the Copyright Society, and it's the first article that examines how copyright terminations are impacting what I call the old school hip hop catalog. All that good hip hop music from the late 80s, early 90s is now up for termination. And most of it's not happening because most people don't know about it. And secondly, they can't navigate the Byzantine provisions of that. So the other thing is, and I think Lisa touched on this, is we have works made for hire. If the work is deemed a work made for hire, then there is no possibility of recapturing the work ever. The record label or whoever owns it will always own it. They'll own it forever and ever and ever. And of course, this came up too in the George Clinton matter. So for those of you who don't know, Clinton was a 70s artist. He's still alive. He still performs. Can't perform with COVID. If you ever get a chance to see him, go. He's at 77 or however old he is, he'll knock the socks off of any of these young cats who are out there or gals out there. I tell you that. George Clinton is a complete musical genius, and he's at the foundation of hip hop music. So he's an American icon. He may be the greatest American living, musician. I mean, there are others that could maybe claim that crown, but he'd have to be in any group that we talked about for it. And yet, when in the Ninth Circuit case, one of the things and why he lost and ended up losing his sound recordings, by the way, was that when Warner Brothers signed him to his deal in the 1970s, mid 1970s, late 1970s, of course, when they filed a copyright certificate, you have to claim how you own it. When you file a certificate, you got to claim, well, how are you the owner? There are a number of ways you could create the work, you could have the work transferred to you, or it could be a work made for hire. So of course, Warner Brothers, who I worked for, full disclosure, I worked for HBO years ago, put in the contracts, and they still do, it's a work made for hire. However, that is not true. The statute doesn't say that sound recordings are a work made for hire. This is a big, big issue that the courts are going to have to decide at some point, and it's going to be a major issue, and there's going to be lots of trepidation about this, right, for it. So that's some example. Okay, Lisa knows I always talk about this. I am appalled with how American law treats performers. And here it gets worse. Because if you understand copyright law, you understand that there's some monies that have to be paid if you're the composer. If you're the composer and somebody publicly performs your song in a restaurant, in a sports arena, in a disco, every time your song is publicly performed, you're entitled to copyright royalties. And if they're not paid, it's copyright infringement. Also, every time a song is made in any physical form, like a CD or vinyl, there's another set of royalties they call mechanical royalties. those have to be paid. In my experience, when I was doing record deals often that was the only money you'd ever see, those mechanical royalties. All that rigmarole about advances and all that, you're probably not going to get anything. In fact, many times you'll end up owing the label money. But you will get mechanical royalties. And if your song is being publicly performed, you'll get performance royalties. However, these people don't get them. Performers don't get those royalties. And as a result, they often get nothing. Lisa, I'm sure can attest to this. There are many record deals where records have sold, Spotify, whatever. They've done very well, and the person got nothing. Why? Because you only get based on the contract. And if you're only getting based on the contract, you're in a bit of trouble.
I know what love is meant to be. 'Cause our souls touch tenderly. Love is life and life is living. It's very special. Baby, don't go. Baby, don't go. Baby, don't go.
That was one of J-Lo's biggest hits. It was called All I Have, featuring LL Cool J. And of course, the thing is that Deborah Laws, as merely a performer and not a composer, the only rights she has are the rights that are granted pursuant to the record deal that she signed when she did that song. It was a 70s song. It was a hit for her. She was a very young girl. I want to say she was 21 or something. She was real young when she did that song. Now, when you sign that deal with the recording company, with the record company, they don't understand. That deal says we own your performance. That's what a record deal is. And we're going to put it on this sound recording, and we own that 100%, and you don't own it. And by the way, you can never get it back, because when we file in the Copyright Office, we're going to file it as a work made for hire. Now, what kind of system allows that, right? Every time I hear that song, it makes me very sad. This young girl singing her heart on this song, making the record, because she's not the composer, the record company owns her performance, and then J-Lo can do whatever she wants in her song. And yeah, so she's victimized yet once again. This is the system. I often use Ronnie Spector too, the Be My Baby, because she performed that song, but she didn't write it. Phil Spector wrote it. And when she wanted to use the song in her own Broadway play about herself, he wouldn't even go, because guess what? He doesn't have to do that. George Clinton has gone to the courts time and time again, alleging that he was defrauded out of his copyright compositions and his sound recordings. And time again, the courts kick him out of court. The courts have no sympathy generally for people claiming that they were defrauded into a contract. That's one of the hardest claims you're going to make. And I think it's heartless. I think it's cruel. And I think, the only way to do it would be to completely change contract doctrine. Contract doctrine is set up now so that you really can't make claims for fraud unless you have a smoking gun evidence of fraud for it. But Mr. Clinton contends that contracts were signed on his behalf, and by the way, I believe him, that basically divested him of all his royalties for his compositions. He doesn't own those compositions. Now, if you think there's a problem of a past, think again. I want to keep saying that. This is happening today. And that's how I'm going to have to bring it home, because we're running short of time.
A millionaire, I'm a young money millionaire, tougher than Nigerian hair. My criteria compared to your career just isn't fair. I'm a venereal disease, like I'm in.
I believe the disease part, at least. So, Lil Wayne, of course, he's Young Money, his company, but of course, he also collaborates with Cash Money Records, which is owned by Mr. Birdman. And if a lawsuit is to be believed, that was filed, the deal was that they would share 50-50 in the copyrights as part of this collaboration between Young Money and Cash Money. All these monies always get me confused too, right? Young Money, Cash Money. Now, however, pursuant to the lawsuit, when Lil Wayne finally realized that he hadn't gotten $10 million that was due under that agreement, and by the way, by my lights, it took him 2 years to figure that out. And I would say, how can you not know that you're owed $10 million? That's something that you have to know. I know when I'm owed $50, right? So I still know somebody who owes me $50. And I still think it was a couple of years ago, man, that guy owes me $50. He didn't know he was owed $10 million. Lo and behold, because of the lawsuit, when he looked at the documents, his lawyer looked at the documents, it showed that the copyrights were registered in the name of Cash Money only. The potential for fraud is rampant, and it is real, and it is still happening today. This is part of the common law contracts. I saw Lisa talked a little bit about unconscionable contracts. This is an offense to breach a contract. It can help you get out of a contract. However, good luck with that. If your defense is unconscionability, good luck with that. Because most of the time you are not going to prevail. You have to show that it was substantively unconscionable, meaning, grossly unfair. And you have to show it was procedurally unconscionable, meaning that the way that the contract was entered into was shady in essence, right? So you have to show two prongs in California for that. It's probably not going to happen, right? The number of cases where you win on unconscionability are like hen's teeth, right? It's not really a viable doctrine. Now, of course, Courtney Love, back in, I want to say 02 or 03, was somewhere back in that period, brought this suit against Universal after she refused to deliver albums to them. They sued her for breach. She countersued for breach of contract, and she asserted unconscionability. Her position was the entire music industry contract model is unconscionable. This is a big lawsuit. I don't know if you remember that, Lisa, when it was going on, but it was a big deal. She finally, after all these years of people being mistreated, who is the one who finally brings a suit and the wherewithal? It's a white woman, right? There's not all these black people who this has been happening to since the music industry was created. I found a little bit of irony in that, quite honestly. And also, I don't know if Courtney Love was really the right messenger for that. One of the things she said in the lawsuit was that she didn't like was the assignment clause, because every record deal you sign with a major label or even a mini major says, hey, we can assign this contract to whoever we wish. And I've been on the other end of that. I had a client that was signed to Tommy Boy, and then later on, they just send him the Zomba records. And they can do that randomly. They have that assignment clause. They can send you. In her case, she was signed to Geffen Records, which was kind of specialized in rock and roll. And they assigned the contract to Interscope, which is best known for rap music. So here we have this, I don't know what to call it, alt rocker or whatever. And now she's signed to a rap music label. This is terrible. But right now, I think Lisa can attest, you cannot negotiate your way out of that clause. I don't know, Lisa, I've never had any experience. In fact, I thought if you try to negotiate, it shows that you're a newbie or you don't know what you're doing. Because they want to be able to assign these contracts like trading cards, right? And send artists around. And by the way, the artists who went to Zomba, they weren't doing anything at Zomba. So we contacted them and said, can you let them go? You guys aren't doing anything. Nope. In that time period, they wouldn't let you out of the contract either. They weren't doing anything with you, but they wouldn't let you out of it, right? We gotta go. So the first song was Richard Berry, who wrote Louie Louie, and the second group was the Kingsmen. The Kingsmen made that, the #1 song in the United States. That was, probably the #1 song of that year, whatever it was, 64 or 63. Louie Louie. It's an iconic rock and roll. Everybody covers. It's been covered by everybody on the planet. So if you own the rights to Louie Louie, today you are a multimillionaire. You own those rights. However, Richard Berry, because he wanted to get married, assigned those rights for like $500 or $600 in 53 or 54, whatever year it was. And copyright law allows this, and so does contract law. An assignment is a transfer of rights from one party to the other. Now, it would be fine if it was fair, but if it's unfair, it's just a mechanism for wealth redistribution. By redistribution, I mean from poor people to people who are very rich, like big record labels and music publishing companies. And that is still with us today. We have the story of Little Richard. I don't think we can get into control composition clause in this time period. It's probably, maybe we could do it another. And I want to end with this. In the book, my book, The Copyright House of Horrors, there's a conversation between Prince, Michael Jackson, and Madonna right at the beginning of the book. And in the book, they're talking about the various ways that they feel taken advantage of by contract law. In the case of Prince, he was very upset with Warner Brothers.
I never meant to call you when it's sorrow. I never meant to call you when you're pain. I don't want to watch that now she's laughing. I only want to see you laughing in the purple rain. Purple rain, purple rain.
So we all know Purple Rain. Here's the thing though, he signed his Warner Brothers deal in 92 after Purple Rain. Purple Rain was like 88, I want to say something in that time period. And when he signed his deal with Warner Brothers, I don't know if his lawyers told him this, he didn't understand conditions. I teach contracts, and I always teach my students, a condition is an event not certain to occur, but which must occur or the other party's performance is excused. And the conditions in that Warner Brothers contract were thick and they were dense. And if he had been told, and I think he would have been maybe so upset if he had been told this, I don't know, he wasn't, but I'm pretty sure he wasn't, that in order for him to make the $150 million or $175 million, $92, remember, in that contract, which would have been bigger than Michael Jackson's contract and Madonna's contract, he would have had to do at least 3 Purple Rains. And if I calculate right, he would have had to do 4 Purple Rains. Purple Rain was a one-off. He did Purple Rain, and all his work is brilliant, but nothing came close in terms of sales of Purple Rain. There were conditions, there were contingencies in that contract. He didn't understand that. He also wanted to release product whenever he wanted to, which isn't how Warner Brothers rolls, right? They have a schedule release, and they don't want you to release stuff and saturate the market. So he was unhappy about that. So he talked about, they talk about that in the book. In the case of the Jackson 5, okay, that was the Jackson 5. And they didn't write any of those songs, first of all. Those were run by a company literally called The Corporation. And that was Berry Gordy and his cats. And so you have to understand that the Jackson 5 aren't making a lot of money, even though they have all these #1 hits. I Want You Back, Stop the Love You Save, I'll Be There. I didn't name them all, right? There's a whole bunch of them. Dancing Machine. They didn't write any of those songs. So they're not getting the songwriting royalties. They're only getting what they get pursuant to contract. When they wanted to leave Motown in 78, I want to say, 78, 79, it was somewhere in that period. Berry Gordy and Motown said, great, you can leave, bet. But here's 2 things. #1, Jermaine stays because he's married to Berry Gordy's daughter. #2, you can't call yourself the Jackson 5 anymore because we own the trademark. Now, this is inequitable contracting. When they own, and Lisa, I know you would never permit this. And that's why in that brief period before Michael Jackson blew up with Off the Wall and then became Thriller and all that, they had to call themselves the Jacksons. They couldn't call themselves the Jackson 5 because of the trademark. Finally, of course, Cardi B. Because I say it's from Jelly Roll Morton to Cardi B.
I like diamonds, I like stunning, I like shining, I like $1 million deals. Where's my pen? Bitch, I like it like that. I like it like that. I like it like that. And I want it like that. I like it like that. I got the soul, I got the feeling. I like it like that.
Okay, so that is Pete Rodriguez, the performer. It was written by a guy named Pabon, and I can never remember the other one. The song was called I Like It Like That. And there was this music in the late 60s, early 70s that arose in the South Bronx, Puerto Ricans. It was called Boogaloo music. So Pete Rodriguez is the founder of that. However, because he didn't write that song, someone else did, he has no rights in it. And it was funny, when Cardi B blew up, they asked him, he said, wow, I didn't know about it. My grandkids told me about it. So, no one even told him, yeah, we're going to remake this song that you made famous as the performer. But Cardi B, in her first contract, which was litigated, and they settled it, I think, last year, her manager was this guy named Shaft. Well, that's a bad sign right there. Wouldn't you say, Lisa? When the manager's name is Shaft, that's not good. And if you look at that first deal she signed, and she was not represented, by the way, with Shaft and this other company, she was giving up 50% of everything that she would make under that contract. Once again, to show you that, for those of you who want to say, oh, this is some old problem and that happened, wrong on 2 counts. First of all that stuff is still under copyright. Secondly, it's still happening to this day. And then I'm going to stop here, and we could share some ideas for reform, including what they're doing in South Africa and reparations. I've now concluded my opening statement.
I'd like to just add something really fast. It's from this article that you sent me earlier this week, KJ. I see this as a call, and I just feel like it needs to be said for all our audience here and everyone else. If the music industry wants to support Black lives, labels and platforms can start with amending contracts, distributing royalties, diversifying boardrooms, and retroactively paying back all the Black artists and their families they've built their empires on. Discrimination has no place in music, and the hugely significant contribution of Black artists to our music and culture must be rightly recognized and valued. I rest my case.
Thank you so much for such a lively presentation, such an informative conversation just between the both of you as well. Thank you, everyone. KJ, Lisa, thank you so much.